I'm Haze Hartwig. This is Bamboo, Vancouver's property management and investment podcast. Hello, everyone, and welcome to the show. Today we are meeting up with Michael LeBeau of LeBeau Law. So he is the man with the name on the wall. He's the big cheese here. So welcome to the show, Mike.
Thank you very much. Happy to be here.
Great. So quick question before, what did you do before you were in law?
Mostly school. I kind of always knew I was going to be a lawyer. My parents told me I argued too much ever since I was a little kid. So I had kind of mostly always planned on becoming a lawyer and just worked my way through school and had a few jobs along the way. But it was always the plan. I always intended to do this as a career. I didn't originally plan on getting into real estate. That was sort of an accidental occurrence. Yeah. But I originally thought I would go into intellectual property, and then I took IP in law school and realized how boring it was, and decided that it was not the cool video game sort of thing that I thought it was going to be when I was growing up. So this came along sort of by accident, by doing a few transactions and ending up enjoying the industry and sticking with it. Yeah.
Did you find it was different? Because most of us see legal stuff at All America, rah rah kind of thing, and here I imagine it's a little bit different.
It is quite a bit different. I worked for a criminal and immigration lawyer before I went to law school for a few years. Did a lot of immigration work, and he was a fairly prolific and prominent lawyer who did some pretty big trials and stuff on the criminal side as well, murders and stuff. And it's not what you see on TV. Yeah. It's concerning at times because of the players involved. I didn't particularly like the client, so I didn't really want to go down that route. But it's also a lot more boring than you see on TV.
Yeah, I imagine.
It's not quite the same as the Columbo and Matlock kind of stuff. So.
I gotcha. Cool. So we'll get into it. We're leaning more towards investment and that. And a lot of the questions that we get through this is group purchases, because as I'm sure you've seen through doing all the real estate legal stuff, that homes are expensive. So people have to kind of team up and work in pairs or groups or family and all that stuff. So a lot of what we need to know is how to do this without losing your marbles and your friendships and so on.
Well, and that's kind of the biggest challenge. Group purchasing is one of the ways that people can afford to do it, but it also presents challenges that, from a real practical perspective, are things that people just have to take on as challenges. There aren't perfect answers to most of the questions involved in this stuff, because every decision that you make along the way in your structuring and your agreements and your contributions and everything can lead to challenges down the road. Everything's fine until it's not.
Absolutely.
That's something I tell clients all the time, whether we're doing family transactions or, like brothers going and buying a place together, parents and children buying a place together, or whether we're doing, friends or business associates buying places together. Honestly, the more third party the people are from each other, the more arm's length they are from each other, the less likely there are to be problems.
Yeah.
Although it makes it easier to fight over things too. So
yeah, absolutely. Right.
And because I've seen families fall apart.
Yeah.
Over real estate investments.
So. Yeah, absolutely. When money gets involved, it can change a lot of things with a lot of people.
Yeah, that's why a lot of the case law in any particular industry is Smith versus Smith, or, re the estate of Smith or whatever. And it's all families fighting with each other. So.
Yeah, absolutely. So as far as legal structures go, what would be most suitable for real estate investment group repair sort of thing?
So that can depend a lot on the people involved. Again, there isn't a perfect answer. There isn't always something that works for every situation. Sometimes it's best just to work as individuals. Two individuals line up and purchasing based on their relevant proportion of investment. So if somebody's contributing 70%, somebody's contributing 30%, they can go on title that way and have that as their structure. One of the reasons that individual ownership is more common than company structuring or partnerships or anything like that is to do with cost of structure as well as lending capacity. A lot of I'm not a mortgage broker, but I do know that a lot of lending doesn't really occur with new companies that are just formed. For example, a lot of lenders just won't lend to that kind of thing. So, if Jimmy Smith and Susie Johnson want to go together and buy a place and want to form a company to do it under some sort of limited liability corporation or something like that, they're going to probably have troubles getting financing and are probably going to have to put it in their personal names anyhow.
Okay, yeah, which is kind of interesting because one of the questions is it better to have purchased in a group names or in holding companies? So I guess you sort of touched on this, but maybe elaborate on that bit.
Again, it really depends on the situation. So, and I'm sorry that a lot of my answers are going to sound like that, but it's the reality of anything from a legal perspective. Is
the lawyer answer? Yeah, I'm not guaranteeing.
Everything is. My wife hates it. I couch every comment that we make for making dinner plans on the weekend. Yeah, I should be able to make that work. But anyways, the structure of the ownership can be beneficial in different ways. One of the nice things about doing it under a company structure is that you can have some of the limited liability side of things, although liability and property ownership isn't really a major concern most of the time.
Yeah.
And so that can be nice. Tax purposes, keeping things sort of separate, although really if most stuff is done in it's a good conversation to have with your accountant as to structure, but if it's done certain ways, the tax consequences usually end up to be more or less the same. The main thing with having it in a company structure is that you can keep retained earnings within the company and not have to pay as much tax on it if the earnings are significant, and that will come into play more often with disposition of property at the time of selling it as opposed to the actual day-to-day operation. Because, for example, you might have a structure where holding company A is the actual legal owner of the property, but holding company A is owned by holding company B and holding company C, which are owned by the two partners that are, the B and C are owned by the actual people that are investing. And that ownership structure is done so that when that property sells and A distributes the profits to its shareholders, being holding companies B and C, those holding companies can then do with those retained earnings what they want to do from a tax perspective, as opposed to if it's Jimmy and Susie that are on title, when that property sells and those profits are distributed, those people are going to pay tax on that money, full tax right away as income for that year, or as capital gains, depending on the ownership structure and or the their tax structure and whatnot.
Yeah, absolutely. And that sort of makes sense. It's a good segue, actually, because if it's being held by a holding company and the two other partners are not holding companies, is that feasible? Is it okay to be Joe Smith and holding company A owned by his partner, or
so
ill-advised?
It is possible. The main issue that would arise, and this gets a little bit more into the tax accounting side of things than into the legal side, but I think what would happen in that case is that you sell that property and the holding company A that owns the property is owned by an individual and a company, and it distributes the profits to that individual and that company as the shareholders. That individual won't be able to do retained earnings. They'll have to report it as income or capital gains in that year, depending.
Okay. Yeah. So sort of different ways for the tax stuff. That's kind of not our realm. We'll stay in our lane.
Although I think that another thing to consider, though, too, is that those investors, the group members, the partners, could potentially keep those funds within the holding company A and reinvest them. But if they're looking to dispose and disperse, then that's where they would have their conversations with their accountants about, oh, geez, should we have done this differently 6 years ago or whatever.
So what is a good way that they can protect their individual interests to ensure fair distribution of profits, like within the group, like as you were talking about, not disposing of if you keep it in holding company, like can there be an addendum or something to just say like, hey, that's still my money, but it's being kept over there right now, or how does that work?
I think a lot of that would be to do with resolutions of the company, like how the company governs itself, which would be a really good conversation to have with my associate here, Sunny Chung, who handles all of our corporate structuring and whatnot.
Oh, nice. We'll be sure to get her on there.
Yeah. She has a lot of really good insight stuff like this as well. But what would happen would be you'd look at your shareholder agreements about how funds are used and distributed, and the as well as the director's resolutions, and also co-ownership agreement. If in a case where it's a company, if it was holding company A that owns the property, for example, you would rely on those shareholder agreements and the articles of the corporation and whatnot, how the company is structured itself to determine how those kinds of funds will be released and dealt with. There is always the risk that one partner may screw another partner. And I mean, that happens in companies, and, people say, oh, he drained all the money from the company and now we're suing him for $600,000, whatever, that sort of thing. But in the other vein, if you have just individuals that own the property, the best way to protect each other is through something that we would refer to as a co-ownership agreement, where the parties come together in an agreement on what the terms of things like distribution, termination of the agreement, if one person wants out, for example. I know there's maybe some talk of talking about things like shotgun clauses and that sort of thing. Those co-ownership agreements deal with most of those types of issues. So how contributions initially started, how people continue to contribute, what everybody's responsibilities are, what happens if somebody's in default of the agreement, what happens if somebody wants to get out of the agreement, what happens if somebody dies, all those kinds of things. And that it would be the same thing whether you're looking at your co-ownership agreement or your shareholder agreements. You're going to be dealing with the same types of matters in those agreements. It's just going to be a little bit different structure, whether it's a company or individuals that are involved. Or partnership agreements if you're going with like a limited liability partnership or that sort of thing. Or just a limited partnership, whatever the case. But then you have more complex structures where you have, because the only people that can own property are individuals and corporations. Because corporations are considered people, and I'm using air quotes that the listeners can't see, for the purpose of owning property. But a partnership is not a corporation and it's not a person, so it can't legally own property in BC. So what happens is that partnership forms a company, and we usually refer to as a general partner, and that general partner becomes the owner of the property. And this is getting into more complex ownership structures of partnerships and whatnot. And where we see those is usually more in like on developer side or more complex. We're not talking about Jimmy and Susie buying a condo together to rein some profits in. We're talking about people that are doing larger scale things.
Now, just for our listeners who aren't aware, because a lot of our guys are new, what exactly is a shotgun clause? What does that mean?
So shotgun clauses are usually meant to be ways to trigger the termination of an agreement, or to, sometimes it's about buyouts. I'm going to try to keep this part of the conversation fairly simple and straightforward, and how it would mostly be relevant is, for example, in our relatively standard, our starting point co-ownership agreement, I don't want to call it standard because it's always customized to everybody that we use, but I have a sort of baseline that I work from. And in that we have a termination section, and basically it really just reflects what would happen if it went to court anyways. And it's essentially, Jimmy wants out, Susie either has to cough up the money or they have to sell the property. Because Jimmy wants out, and Jimmy doesn't have to. Nobody has to own property they don't want to own. So Jimmy could potentially sell his interest, depending on the structure of the agreement, to another person. So if Jimmy wants to sell it to Timmy, I don't want to confuse listeners with Jimmy and Timmy, but too late now. Then Timmy could potentially buy in and then be in that agreement with Susie. Susie would have to approve it and so on. And Susie might, because she can't afford to buy Jimmy out, but also doesn't want to lose the potential value that she sees in the property. And so they look at modifying the agreement that way. That's one thing that can happen. Or more often than not, the property gets
gets
sold.
sold.
Yeah.
That makes sense. Which also touched, and you mentioned about what happens if one of the group members dies. Now, does this fall in the same as like joint tenancy and whatnot? Like, what are the two different agreements that you can do?
So we're generally going to, in an investment kind of situation, we would almost never use joint tenancy, except in some family instances where you might have siblings that registered as joint tenancies and then have agreements as to how they're going to deal with the estates.
Yeah, so I'm sorry, just to interject, because there's the two different...
What joint tenancy and tenancy common
exactly. You need to explain that for your listeners.
I'm going to get to that. We would almost never use joint tenancy in an investment situation. It would almost always be tenants in common. And so what the difference is I kind of like to illustrate this by visualizing a bubble. If you're joint tenants and you're in a bubble, both people that are involved are or all three or all 10 people or whatever the case are all in that one bubble. If any one person is eliminated from the bubble in some way, passes away or whatever the case, they die, that person is removed from the bubble. Everybody else is still in that same ownership bubble. So if it's two people, you and I own a property together and I die and we're on as joint tenants, usually spouses, the surviving owner retains legal ownership of the property. They might not retain full beneficial ownership of the property, which I'll talk about in a second as well, legal versus beneficial ownership.
Of course.
But they would retain full legal ownership of the property and without having to go through the whole probate process involved in wills and that sort of thing. And that's to be contrasted against tenants in common. And tenants in common is where people own properties in fractional interests in shares. We often refer to it as percentages, but our land title system is actually based on fractional interest. So you can own 1/4, 1/2, 50 1/100ths. It doesn't matter how you word it. It has to be a fraction that totals 1 for the totality of the ownership. So we might say you own 50%, but you really own a 1/2 interest.
Okay.
And where that's different than joint tenancy, because joint tenancy, you might practically speaking own a 1/2 interest, but you might practically speaking own a 1/2 interest. The actual legal difference is that in a tenancy in common, that ownership doesn't pass to the surviving holder. It passes to whoever the person who's passed away's estate.
Okay.
So whether they have a will or not, whatever their estate is made up of is where their ownership will go. Sometimes that person may still be the surviving owner, but it has to go through a different process to get to that person than it does if it's joint tenancy. Basically probate versus not.
Okay.
And so that's where the big difference is. And the really good thing about fractional interests is that when I was mentioning earlier, something like 70-30 for people's contributions, you can register your title that way. You own 7/10, I own 3/10. So that means you pay for 70% of all the bills. I pay for 30% of all the bills.
That seems to make sense.
And then when we sell the property, you get 70% of the profits, or you pay 70% of the loss.
Yeah.
And I pay 30, or I get 30, depending on what the situation is. And that's what the benefit of, like, sometimes keeping things simple is easier. You've got two people involved and you have this 70-30 division. It can be 50-50. It can be 90-10, whatever the case. You structure your land title to reflect the nature of the agreement. And you do your co-ownership agreement to reflect the same thing. And everybody contributes those amounts. And that's how you run through the whole ownership structure.
So that's sort of a better structure, almost, you'd say, give or take.
Simpler. Eliminates some of the more challenging problems that can occur in company ownership and shareholding and that sort of thing. However, doesn't really have the tax benefits of those other structures. So that's where you can gain from pros and cons to everything, right?
Yeah.
I did want to touch on the legal versus beneficial ownership thing too. Absolutely. So how our land title system works is that what is registered on title, let's say, for example, two people are going in together to buy a property. but one of them has really shitty credit and can't qualify for a mortgage but has cash. They got all their money in crypto. I'm dealing with a client right now who was a poker player. So made a bunch of money in poker earnings and investments and stuff over the years. And so may not sort of be a standard mortgage lender's favorite.
Absolutely. I can understand that.
So that person might not be able to go on title because can't get approved for the mortgage, but has money to invest. So Jimmy's are subpar credit risk, and Susie's are 9 to 5, solid job, good income, bank's willing to lend her $1 million, whatever the case. Susie goes on title as 100% and then has a side agreement with Jimmy that he's paying for half the stuff and they own it all. So Susie is the legal owner of the property, of 100% owner of the property. But Jimmy actually has a 50% beneficial interest in the property.
Okay.
So when that property sells, he can get half the money of the profits. He won't always know. Like Susie could, potentially screw him over or try to or whatever. And then he would have a cause of action because they would have an agreement that says that he has a 50% interest in the property and the beneficial ownership. So if she's not sharing the profits properly, blah, 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 like that becomes a fight over it.
That would obviously be like notarized or something of this nature.
Yeah. Usually you kind of run into some challenges with that stuff where a lender doesn't want to know about Jimmy.
Okay.
So Susie and Jimmy would usually have to do this as a separate kind of thing. I'm not advising defrauding lenders, of course, because that's a whole different challenge. But and because now we have a lot more transparency related stuff with our land title system, there's a landowner transparency registry where Susie has to declare that Jimmy owns a 50% interest in that property at the time that she buys it. And so this is where problems now occur that didn't used to occur. Susie's supposed to tell her lawyer that's helping her buy the property that Jimmy has a 50% interest in it. And then that lawyer has to say, well, Scotiabank didn't approve Jimmy, so we can't have anybody else have an interest in the property. So either Jimmy doesn't exist but if she doesn't declare him, then Susie has potential problems from like a government perspective and potential tax implications down the road, because then she could be held liable for all the profits of the company and all. So it gets into whole like trust and transparency stuff. Yeah. So it becomes a bigger problem. It's really better to keep everything above board. Okay. Just saying that some people may occasionally try to do things on the side to change how they show their ownership. Yeah. Now, being with that there's a pair of people in this example. What should be done, like if there's a conflict in the relationship? Say the furnace needs to be replaced. One person wants to do it. The other person's like, let the tenants be freezing cold. So, what if there's a dispute? Yeah. And so again, this comes down to the whether it's the shareholder agreement or the articles of the company, if it's a corporate structure or the co-ownership agreement. I mean, it's all going to come down to the same kind of issues. Mm-hmm. Those agreements should have something that says that it's like whose responsibility it is to pay, which let's say they're 50-50. The agreement's going to say they're equally responsible to share the costs of the repairs and the maintenance and so on of the property. And if one of them refuses, they're actually in default of the agreement. Mm. What happens then? Yeah. Well, then Susie either has a cause of action against Jimmy for not wanting to abide by the agreement. Mm-hmm. So she can either terminate the agreement and buy Jimmy out. Yep. And force the sale to her, or force the sale of the property, period, because she's like, well, I'm not going to get sued by my tenants by keeping them freezing in minus 20 degree winter hit, because Jimmy doesn't want to do his part. So we have to sell the property. So then Susie would pay to fix the furnace, and then she would be compensated for it upon the disposition of the property. Okay. And that's the other thing that can happen too, is that sometimes an owner, like one of the owners, might take on the cost of the expense, but then the agreement basically says that if somebody pays more than they're supposed to, they get compensated upon disposition, kind of thing. So you have to keep track of everything. Is really what it comes down to. Yeah, absolutely. And now I'm sure that you've seen people go along the routes of buying one another out type of thing.
how do they come to the price that's fair? Because obviously a property can go up, but you don't know the actual value until someone buys it. So what's some methods that you've seen used that maybe save the friendship or the family?
So our agreement outlines a method for determining value. And it will be, so if in a buyout situation, it would usually be a third party appraisal, or the parties can agree on a value. That's something that can happen too. They can just agree on a number. They can get a third party appraisal, like an actual appraiser to do it, or they might use realtors to give price opinions, and either like maybe get one realtor each and average them or something along those lines. They can determine what they want to do, but the best way is to get a third party appraisal. Yeah,
so I guess sort of pick together maybe and do two appraisals and then average it out kind of thing, just because somebody could be in someone else's pocket, or
it's possible.
You never know, right?
Yeah. And so if there was doubts about the appraisal, it would usually have to be an independent appraiser, though, would be the goal there.
Okay. So now, prior to acquiring as a group, what would be some due diligence that like groups should do together beforehand? I mean, obviously, make sure you got the cash would be one of them, but people are in different sections of their life. What's some I mean, obviously, we don't want to get right into it, but like a couple of things that someone should ask maybe before we jump in bed here.
Honestly, my opinion on this is to know who you're jumping in bed with.
Yeah.
And I mean that, like, know them very well. And you have to be willing to be very open with each other about books and records and finances and stuff. And if somebody is hesitant to be open with you, my advice is not to jump into bed with that person.
Yeah, exactly. Err on the caution, right?
I believe the kids refer to those as red flags. The reality is that I think it's really just coming down to comfort level on what you know about that person, and I don't know, maybe ask for each other's tax returns or employment confirmation. I mean, usually in theory you'd be doing it with somebody you know fairly well. But you also don't know like what their credit history is like. Maybe they have a bunch of debt that they're carrying that you could get screwed with, because that's a concern with this sort of thing is, Jimmy and Susie own this property together and Jimmy carries a huge amount of debt and goes bankrupt. Well, Jimmy's share of the property is subject to insolvency. So that can be a problem for Susie, because then she's dealing with a property that may have to get sold that she didn't want to get sold, but can't afford to buy out, because it turns out that Jimmy's a delinquent, degenerate debt acquirer who has dragged her down and drags her finances down too, because suddenly he can't pay the mortgage and then she can't pay it by herself, and and then just snowballs up into that. So basically, on a very loose, what would you say your top 3 things you should check for at a minimum would be? I would think probably have to be willing to show each other like credit checks, maybe just pull each other's credit reports, and a last 2 tax returns might be a good idea. Like the same stuff you give a bank.
Okay.
Really.
Yeah.
And if you're applying for a mortgage to do it, because most people can't afford to buy cash, maybe that's part of it, is that this all has to be open between everybody. And so, employment confirmation, credit checks, and tax returns to establish validity of the information that's been provided.
Yeah, that absolutely makes sense. And speaking of documents and all that, can you explain the process of acquiring and transferring property titles when investing as a group, and sort of what documentation is required, or how is it different from just doing it as an individual even?
I think it depends on the structure of the ownership. Like if it's done as 2 individuals, we would do it the same as any other husband and wife buying property, or husband and husband, wife and wife. I'm not judging.
Yeah.
Whatever the case, whoever are buying the property as individuals, we wouldn't really do anything different. The only difference would be in how we structure that title, whether it's joint tenancy or tenants in common, and what fractional interest for the tenants in common percentage of ownership would usually be the case. And at that point, we'd probably start talking about writing co-ownership agreements and that sort of thing between the parties, if that's what they wanted to do. if companies get involved, it gets a little bit different, because then we have to look into, a lot of it will depend on how the lender has it structured as well. But that's where we get into things like, company structure, ensuring the company is legally able to own property, the shareholder structure set up properly, and all that kind of stuff. So it would be mostly to do with company structure and shareholder agreements. And it's kind of the same thing, whether it's individuals or not. There's just the actual type of documentation is a little bit different in a company setup versus an individual setup, but the contents are fundamentally the same.
And that's something that Sunny, your colleague here, would probably be more suited to answer. So we should definitely get her on the show here.
And she can speak to a little bit more about when it comes to the company stuff, whenever we're acting for borrower and lender, because whenever in a standard purchase, the lawyers always act for the borrower and the lender, unless it's private financing or something like that, or it's commercial lending or that sort of thing. But in a non-commercial structure, that's something like we're talking about, just a couple of noobs getting together to buy a property, and they formed a little company together, or whatever the case. The documentation is, we just have to deal with some corporate structure stuff to go along with that. We have, the articles of the company, the shareholder registry, the shareholder agreements, the director register. There's something called the Central Securities Register.
Okay.
That is really the shareholder register, shows who actually owns it in what proportions. And then if that company is owned by companies, then this all kind of gets bigger and spirals a little bit.
Yeah. Now you mentioned earlier at the top of the show that if they formed a company that they can't get lending, so how do you buy as a company if you can't get money to do
It's not that they can't, it's that it's harder.
Okay.
And it's not always impossible. I mean, we've done them before.
Mm-hmm.
I've done many, often with CIBC, oddly enough. And that tends to be one of the more common ones that will accept a company on title. Because what happens is that in those cases, the lender requires that the owners give personal guarantees.
So like their own home type of thing?
Or they're not their own home, but their own pledge. So the company isn't the only one liable for the loan.
Okay.
The individuals that own the company are also liable for the loan. And they're what we call jointly and severally liable. Mm-hmm. So they're not only liable for their portion of the loan or the mortgage, they're liable for the whole of it. So if Jimmy screws off and leaves Susie, Jimmy moves to Bali to become a surfer, and Susie's left holding the bag, Susie's still responsible to pay it all. Okay. So
really know who you're getting in bed with. Going back to that, right?
Exactly. Be careful for surfers. The idea being that when we sign the documents, those clients will have to sign personal guarantees as well, and often have to get independent legal advice because we are acting for the lender as well and the company. We would commonly, depending on the situation and who's involved, we would commonly have to send the individuals to totally separate law firms to get independent legal advice to advise on their personal liability in the transaction, because they are connected to a company that's going to be the owner, but they're going to be just as equally liable for the loan as the company itself. Yeah,
that's one of the liabilities. Are there any other liabilities or risks that, off the top of your head, may be associated with this? Like, obviously, know who you're working with and make sure that they don't have a whole load of debt with them and whatnot. But are there any other ones that we haven't really touched on, or that really stand out for you?
I think the biggest thing is, it comes from know who you're dealing with, but the biggest thing is getting your own credit screwed up because of who you're partnered with, because of how your obligations to the bank can be negatively impacted by their failures, kind of thing. So if Jimmy's not paying and Susie can't afford to pay, Susie's getting dragged down with Jimmy. Yeah. And that's so potential insolvency, potential credit risk. And also, if, Jimmy has those degenerate debts that have accumulated, and suddenly those companies are calling in loans and getting judgments against Jimmy and putting judgments against title to the property, and ultimately trying to get the property foreclosed on, or the sale forced so that they can get repaid, that can negatively impact the situation as well. For example, Jimmy owns 50% of the property and owes more than 50% in accumulated debts and judgments, and those are registered against title to the property. That can negatively impact Susie's potential equity without having a big court battle to fight over, because those judgment holders might not authorize the sale of the property unless they're getting fully paid. And the only way to get fully paid might be out of some of Susie's money as well.
Absolutely.
So there can be challenges in how to deal with that ideally don't involve going to court.
I mean, just stay out of court if possible. Same with the RTB for the property management side. Just stay out of it if you can. And do it amongst yourself. Coffee talk.
Yeah. Work it out.
Yeah. Right.
Yeah.
So for people who are thinking about getting into purchasing with partners, what would be the first step? Do you talk to the mortgage first? Do you talk to set up a company first? Like, what do you figure is the most reasonable way to, measure 3 times before you cut?
Yeah, don't do it. That's no. I know. I'm just kidding. I'm kind of not. Well, I'm not kidding. I don't know. Honestly, it can be fraught with risk, and the challenges that may come. It's so hard to get through, I think, in a lot of instances. So your number one is, can I get financing?
Yeah.
And how can we structure the financing, or how can we structure the partnership, whether it's a capital P partnership or just, however we're working this together, whether it's individuals in a co-ownership agreement or we've gone together and formed a company and all that kind of, all those kinds of options. What will lenders accept?
Yeah.
So that's where your conversation with somebody like Chad Oinhart, the mortgage broker, can maybe advise on to some extent, or work with the lenders to determine what they will accept.
Yeah, we just had him on a couple weeks ago, actually. So
yeah, so that would usually be the best starting point, because that will guide the rest of the forward motion. Because if you need financing, then you need to be able to work with your lending. And sometimes if you start to move beyond the sort of standard residential lending side of things and you get more into almost like a commercial venture, then you would talk to somebody like our mutual friend Josh Richardson on the commercial lending side, who may have options for the people as well. And then we operate on those instructions, right? So you talk to your accountant and accountants, because each person should have their own.
Okay.
They should.
Yeah, that's interesting.
Each person should have their own, and then there would be one for the company as well, usually.
Wow, it's a lot of accountants.
A lot of accountants, a lot of lawyers.
Yeah.
The reality is everybody needs to have their own interests protected, right? And so Jimmy's going to have his accountant saying, well, you need to, because of the totality of your affairs, you need to form a separate holding company, or you put your shares in company A are to be held by your holding company B, because that's what we need from a tax perspective. Susie's accountant says, you got shit all, you just own it as a person, who cares? And so you just need to become an individual shareholder, or you go in together and you declare the transparency ownership for Jimmy, that holding company A, he bare trusts it in his own name, and which is a more complicated discussion as well. But where his company is the beneficial owner, but he's the legal owner, but holds it in trust for his company, which the lender would have to know about as well. Yeah,
it almost seems like it would make sense to make sure that that you do that agreement outside of it, almost just to keep things a little bit cleaner. But as you said, it seems like either way, someone's going to be wrong.
Well, that's just it. Like a lot of things, like to keep it outside, for example, usually involves not telling the lender the whole truth.
Yeah.
And if you're choosing to do that, I have to advise against it, because that's the right thing to do from an advice perspective. People will do it. And if they are going to do it, then they need to be wise about who they disclose what information to.
Yeah, absolutely.
It's about as much as I'll say about that. Keep your mouth shut. It's in terms of who you talk to, like, make sure that only the right people know about what you're doing if you're trying to do something on the side.
Yes, that makes sense.
But really, I don't really advise it, because that's a default under your mortgage, and you can end up in trouble with your lender.
Yeah, and then you're really in luck, right?
Then Jimmy's screwing Susie again.
Yeah, I don't trust this Jimmy guy, man. I don't know about him.
He's a bad dude. He's a bad seed. So
right on. So if somebody wants, because obviously you've touched on quite a few topics, and there's people should not use this as their only advice. They should come actually talk to you.
Yeah.
How would they find you or Sonny or everybody basically to get this show on the road for them?
Yeah, and of course, none of this is legal advice. It's just general commentary.
Absolutely, yeah. Don't go YouTubing how to do heart surgery.
Because everybody's needs are very individualized, and we usually will operate. What I'm saying is, we will usually operate on the instructions from the accountant and the lenders, and provide advice on what those structures look like at that point. But what people need to do is just hit up our website, lebeaulaw.ca, lebeaulaw.ca, and give me or Sonny a call, and we can hopefully walk them through where to start. After they've, and oftentimes that will be, talk to your mortgage advisor, talk to your accountant, and then we will put together what they've recommended for you based on both your tax needs and your borrowing needs.
Okay, and so you're step 3, basically.
Generally speaking, if people are doing it properly, yes, because what might seem like the right idea for us on the face of it, like, oh yeah, open a company, do it that way, it might be a good idea until it turns out it's not, because of tax consequences for that client that they didn't tell us anything about, we didn't know.
Okay.
So definitely, when somebody says, hey, we want to open a company, I say, okay, get your accountant to send me instructions on how they want it structured.
Yeah. Okay. That makes sense. Yeah, absolutely. So those of you who are trying to get a hold of Mike LeBeau, we will have the link there in the description of this show. So thank you very much for tuning in, everybody. If you have found this show of use or interesting, please be sure to like and follow us. We'll be back in a couple weeks to talk about the goings-ons in the market, along with some stats and other things. So it's not just a boring stat show. So thanks for listening.
Cheers. Thanks, Haze.
Thanks.